take your seats. I will just read the normal procedures. Welcome to meeting number 77 of the House of Commons Standing Committee on Justice and Human Rights. We have two of our members virtually today, and the rest, most should be in the room. Pursuant to the order of reference from the House adopted by the House on October 5th, 2023, the committee is meeting in public to continue its study of Bill S-12. Today's meeting is taking place in a hybrid format pursuant to the House of Order of June 23rd, 2022. Members are attending in person, in the room, and remotely using the Zoom application. Just a few comments for the benefits of the witnesses and members. I believe we have one witness virtual and two in the room for our first panel. Please wait until I recognize you by name before speaking. For those participating by video conference, click on the microphone icon to activate your mic, and please mute yourself when you are not speaking. Interpretation for those on Zoom, you have the choice at the bottom of your screen of either English or French. For those in the room, you can use the earpiece and select the desired channel. A reminder that all comments should be addressed through the chair. For members in the room, if you wish to speak, please raise your hand. For members on Zoom, please use the raise hand function, and the clerk is here. He will assist me with that in case I miss someone. Thank you for your patience. Two very quick housekeeping items before we start with our first panel. There was a budget that was circulated by email from the clerk to everybody. Require a motion approving that the expense be paid to the witnesses for their cost to appear. Thank you. Do I take people's names when that? Yes. Thank you, Mr. Housefather. I appreciate that. And seconded by Mr. Caputo. Thank you very much. The second housekeeping item is almost similarly, but in relation to the hospitality expense related to the informal meeting with the United Nations High Commissioner on Human Rights yesterday. That was Monday, October 16. There were three committees involved in that meeting, and we were all asked to partake in paying part of that cost, which I'm told is less than $200. Can I please get a motion that we pay our share? Thank you very much, Mr. Van Popta. Appreciate that. I think you were there yesterday as well. Thank you very much. And do I have a seconder? I don't know if I need one, but thank you. I don't need one. Thank you very much, though, Mr. Brock. No, merci beaucoup. Okay, now, thank you very much, everybody, for your indulgence. Now, I will introduce, one more reminder, if I may. Deadline on S-12. Simply to let everyone know that if there's any additional amendments to be distributed, this is a reminder that please contact Mr. William Stevenson, the Legislative Counsel, as soon as possible. He will ensure that amendments are properly drafted. Reminder that the clause by clause is happening on Thursday, next meeting. And all amendments, including sub-amendments, must be submitted in writing and sent to our committee clerk. So now for our first hour, panelists, welcome. Thank you very much. I'm going to ask your indulgence. What we will do is have each of the three of you speak for 5 minutes. Due to the time restraints that we have, I will go with 6 minutes per each party, and then conclude the first panel. So, which one? Okay. So, we have three witnesses. Madame Robin Parker, avocate. Colton Fair, professeur adjoint, faculté de droit, Thompson Rivers University. Et Janine Benedette, professeure de droit avec Peter A. Ellard, School of Law, University of British Columbia, par videoconference. So I will have Ms. Robin Parker please begin.
Thank you.
You have 5 minutes, and just so that you know, the clerk will take, he will help me take notes, and if I've seen it in other committees, maybe if I go red, it means time is out. How's that? And I'll try and, so thank you very much.
Thank you, Madam Chair. I'm going to speak on publication bans. In 2021, sexual assault survivor CL was convicted of breaching her own publication ban. Her crime was texting the reasons for her abuser's conviction to her friends and family, a group of supporters. The trial judge had described the assault as extremely serious and violent, and her children were in the home at the time that it happened. The trial was long and difficult. She had a community of supporters, a network, some of whom were not in court the day the accused was convicted. So she sent them the reasons for judgment via Facebook Messenger. The accused learned of this and complained to the police. CL was charged with violating the pub ban that had been put in place to protect her. The prosecutor reviewed the file and somehow determined that it was in the public interest to prosecute her for this. They said they would seek jail if she was convicted. She took money from her savings account and hired a defense lawyer. Her lawyer explained if she pleaded guilty, she could avoid jail. Her lawyer would join the Crown in asking the judge to impose a $2,000 fine. Frightened and traumatized, she agreed. As a final insult on the day that she pleaded guilty to something that isn't actually a crime, I'll come to that, the judge imposed a $600 victim fine surcharge, even though CL was the actual victim. The law on publication bans is clear and it's settled. Texting a legal decision to a small group of supporters does not constitute intentional publication, broadcasting, or transmission within the meaning of the criminal code. CL had committed no crime, yet every justice system actor who touched the file failed her: the police, the Crown, her own lawyer, and the judge. I reached out to her after reading about her case in the news. With the help of my colleague Karen Symes, we successfully appealed the decision. CL's conviction was quashed, and her money, including the victim fine surcharge, was returned to her. Her case made national news and galvanized a network of survivor advocates who were having difficulties of another kind with publication bans, getting them lifted. These brave women eventually formed the group who've testified here, My Voice, My Choice. But because of the media attention, survivors across the country started reaching out to me, because I'd happened to have my name in the paper, and to my friend and colleague who you met a couple of weeks ago, Megan Stevens. In the intervening years, I have assisted many survivors get publication bans lifted and advised countless others. And today I bring this practical experience to the committee, as well as almost 3 decades as a prosecutor, a defense counsel, a victims' rights advocate, and a survivor myself. I have seen the system as it deals with sexual assault cases from every side. I share CL's story with you because in many ways it was the genesis of these amendments. But it's important to stress that her ban remains in place because she wants it. The principles underpinning these amendments must be knowledge and autonomy for complainants. These provisions were found constitutional in the Canadian newspapers case because of their laudatory purpose in encouraging reporting. It needs to be easy to have the ban imposed and easy to have it lifted. And in all cases, there should be a meaningful duty to inform the complainant so they can exercise their rights. I welcome and support the amendments in S12, but I echo the comments of others to stress the need for properly funded counsel for the complainant. Most complainants don't even know there was a pub ban in their case, and I would venture to say literally none are consulted before it's imposed. This is why at earlier stages of drafting, together with a network of other lawyers, one of whom is here to testify later, Pam Hrick at LEAF, we lobbied to impose a duty to inform the complainant of the existence of the pub ban. But a prosecutor cannot provide legal advice to a complainant. Every discussion a prosecutor has with a witness is subject to disclosure obligations, and the provision as drafted could put the prosecutor in the position of harming the complainant by having to disclose new information they receive while explaining the publication ban. For example, if the complainant says, "Can I speak to my counselor?" or "I have told my counselor the details of this assault." That may then put an obligation on the prosecutor to disclose to defense something that they might or shouldn't already know, which is that there might be counseling records they could subpoena.
You able to?
I'm almost done. In closing, I just want to say this is an issue that touches every Canadian. There is probably not a single household in this country that hasn't been touched directly or indirectly with sexual and gender-based violence. And so I urge the members of all parties to please work collaboratively to make these much-needed changes to the criminal code. And I thank you for the opportunity to participate in our democratic process.
Thank you very much. I will now go to Mr. Furr.
Thank you.
You have 5 minutes.
Thank you. I'd like to focus on several of Bill S-12's features that respond directly to the Supreme Court's Nlavu decision. At various points in Bill S-12, a disjunctive test is employed for determining whether an exception from the sex offender registry or a termination order is warranted. And the test effectively employs the language of Section 7 of the Charter, and in particular, the overbreadth and gross disproportionality principles. And I suggest that this dual exception is unnecessary. Such an approach is only reasonable if there are circumstances where an overbroad law is not also grossly disproportionate. Yet, if a SWORA order doesn't further the law's purpose, the fact that the order has, per the majority of the Supreme Court, a serious, onerous, and considerable impact on the offender's liberty strongly suggests the effect is also grossly disproportionate. And notably, the original SWORA legislation only employed the gross disproportionality exception, and there's no indication that this exception was too narrow. This is more than a semantic point, because allowing judges to avoid making a SWORA order because they think there's no connection between the order's aim and the offender's conduct invites problematic speculation. As the dissent in Nlavu observed, judges have frequently issued exemptions in highly inappropriate circumstances. They have excluded offenders because the judge thought they did not pose a future threat because they sexually assaulted people they knew, were viewers of child sex abuse materials, opportunistic offenders, or historic offenders. Right? These types of exclusions demonstrate that judicial bias in sexual offenses is present in astonishing ways and with a disturbing frequency, as the dissent demonstrated with its overview of the jurisprudence. And while the proposed amendments provide factors to guide judicial discretion, these factors are stated quite broadly, I suggest. And I agree with Professor Benedict, actually, who suggested in 2012 that factors that are irrelevant should also be listed. These should include the fact that the victim knew the offender before the offense, the act was opportunistic rather than predatory, the offender has ceased the occupation or activity that brought him in contact with the victims, that he was intoxicated, and that the offense did not involve multiple victims or additional bodily harm. Discretion is also made available in other questionable circumstances. Amendments to Section 490.012, subsection 1, would require an offense be prosecuted by way of indictment and there be a sentence of 2 years, a penitentiary sentence, before a SWORA order is mandatory for sexual offenses against children. And we should ask, does the available evidence establish that only child sex offenders sent to the most restrictive prisons in Canada are sufficiently likely to reoffend as a category to warrant a SWORA order? A review of the sentencing jurisprudence demonstrates that even cases of prolonged grooming and with multiple assaults would not require an order, leaving the decision to the discretion of judges, which again has proven problematic. But with that said, Parliament likely wants to allow for judicial discretion not only to protect against Section 7 challenges, but also to keep SWORA orders outside the purview of punishment under the Charter. And it's worth considering, though, whether the prior laws would be constitutional, the mandatory provisions, if conceptualized as serving investigative and punitive purposes. In other words, could SWORA orders not also, and perhaps predominantly, be imposed as punishment given the court's conclusion that an investigative model requires judicial discretion? Under such an analysis, it's not sensible to speak of overbreadth because SWORA orders will readily further the aims of denouncing and deterring offenders from committing further offenses. Nor is it clear that SWORA orders would be grossly disproportionate, as the broader objectives of denunciation and deterrence would need to be given due weight alongside the investigative benefits these orders already serve. And while this approach may engage Section 11I of the Charter, this could be avoided. Retroactive application could be avoided by allowing offenders who committed an offense under the prior legislation to apply for exemptions where the impact on them is not inconsistent with NLAVU. Thank you.
Thank you very much. Madame Benedette, la parole est à vous.
You have the floor.
So thank you for inviting me to take part in this consideration of Bill S12. I'm sorry to have to say that because we're starting just a little bit late, I do have to teach at 2 p.m. Vancouver time, 5 p.m. your time, but I hope I can be here for most of our discussion. So I'm going to focus my remarks today on the proposed changes to the sex offender registry, and not surprisingly, some of the things I'm going to say will track the points that Professor Fair has made with you. I conducted research a number of years ago that was referred to in the Supreme Court's decision in Ndlovu. While I prefer the approach of the dissent in that case, at this point, the decision for you is how to respond in a way that respects the Charter, preserves the integrity of the registry, and reflects the realities of how sexual offenses are committed, prosecuted, and sentenced. As I read the bill, it proposes making registration automatic in a few cases and strongly presumptive in others. And I have two concerns about the current bill that track what you've just heard. One to do with the trigger for mandatory registration, and then the other to do with the factors the judge must consider in deciding whether to grant an exemption when registration is merely presumptive. And so the first of them goes to a point that's already been raised with you, which is that as I read this bill, it is saying that registration is mandatory for first offenders, that it is triggered where the offense is prosecuted on indictment, the sentence is 2 years or more, and the victim is under 18. And this is a very high bar and not obviously required by the Supreme Court. The reality is today that major sexual assaults are often prosecuted by summary conviction for various operational reasons. And the maximum penalty for sexual assault prosecuted summarily is only 18 months. There's an anomaly in the criminal code, unlike 2 years for other summary offenses. And so these serious sexual assaults against children will not attract the same mandatory registration, despite the fact that the circumstances of the offense and the risk of reoffense may be identical. So summary conviction offenses are not invariably minor offenses, and I think it's important to stress that point. The 2-year threshold is also high. The resurgence of conditional sentences for sexual offenses, including sexual offenses against children, means that no offense where a conditional sentence is applied will attract mandatory registration either. And so you will see the avoidance of mandatory registration becoming a chip in plea bargaining, as well as a reason why some judges may sentence to less than 2 years to avoid that collateral consequence of conviction. And so I would just say, if you are being sentenced to imprisonment for a sexual offense against a child, whether on summary conviction or by indictment, surely it cannot be unreasonable to also expect that you will be placed into the sex offender registry. So to me, that trigger doesn't make a lot of sense, and I think could be lowered. The second point, and it's one that's already been raised, is what happens if registration is not mandatory but only presumptive? And here we see the exceptions, and you've heard some concerns with those. The problem we know is that in the past, when judges were given discretion along these lines, they ordered exemptions frequently. My research showed that they did so in up to a third of cases, at least for which reasons were available. So these exceptions weren't exceptional at all. And this is part of a pattern. When judges exercise unfettered discretion in the context of sexual offenses, they fall into stereotypical reasoning. We've seen it in the context of sexual history evidence, private records in the hands of third parties, and in sentencing of offenders for both adult and child victims. There is the myth that opportunistic offenders are not real sex offenders, that men of good standing in the community are not real sex offenders, that where no additional violence is used or children give de facto consent, that these are not real sexual offenses. Now, Bill S-12 does attempt to offer some conditions that must be considered by a judge in deciding whether to grant the order, but most of them are vague and general and permit myth-based reasoning.
Ms. Bennett, I'm not sure if you can.
Yes.
Do you want to wrap it up, or would you like to, or
Sure.
can you leave them maybe for questioning? Okay, perfect. Thank you so much.
I'll leave it for questioning, except to say that I was going to support the point that Professor Fair made. There needs to be a list of factors which the judge may not consider in deciding to grant the exemption. That's present in other parts of the criminal code, and it ought to be used here.
Oh, thank you very much. So, members, we will have one round of 6 minutes each per party, and I will start with Mr. Frank Puto. You have 6 minutes. Thank you.
Thank you, Madam Chair. If I could please just address all of our participants here today. Ms. Parker, I don't know if we've met before, but thank you. I thank you for your courage in speaking out as a survivor and as somebody who has been counsel on these publication ban matters. This is not the type of law that people probably think about when they go to law school, and I know it probably doesn't pay very well, if at all. So I thank you for your sacrifice and for your contribution. To Professor Fair, it's nice to see you. Full disclosure, I spoke to his criminal law class. I used to teach at TRU Law, so thank you for being here. And to Professor Benedette, it's nice to see you. You presented to us when I was a Crown Prosecutor in BC, so it's nice to see you there as well. I have so much to go through here. I'm going to start with Professor Benedette here, and talking about low risk versus no risk. As my colleague Mr. Brock points out, the best predictor of future behavior is past behavior. So given that issue, does it not follow that we should be considering mandatory a mandatory triggering, especially for a sex offense against a child?
Well, I would say yes. Certainly a sexual offense against a child that attracts a sentence of imprisonment, whether custodial or conditional, is a serious offense. And the route at which that is prosecuted, summary conviction or indictment, is really irrelevant. It's the facts of the offense and the penalty it attracts that speak for themselves. So yes, it seems to me that is a circumstance in which mandatory registration is justified and could be supported as constitutional if that were to be challenged.
Now, one thing that I was reflecting on, and anybody can chime in on this, but let's say if we had a joint submission, which essentially ties the judge's hands, except in very rare circumstances, where discretion isn't where registration isn't mandatory. Theoretically, you could actually have a plea bargain that would say this joint submission is such that that we're not asking the judge to impose registration under SOIRA. Would you agree with that? Any of the witnesses? How about Ms. Parker? Perhaps you have a fair amount of knowledge in this area. Feel free.
I'm actually going to defer to, I don't feel I should speak on SORA here today.
Yeah,
I'm actually
fair
going to
enough.
defer to my friends who've studied this much more than I.
Okay.
And I'll defer to
Okay.
Professor Benedette
Yeah.
first, of
If
course.
this isn't within anybody's realm of knowledge, I'll just ask another question.
Well, I'll just say that as I read the legislation, the way that you have structured it, I'm not sure that could be plea bargained away, because even where it's not mandatory, it's presumptive. It's only the secondary offenses where the application has to be made and that could be the subject of plea bargaining. It's a complex piece of legislation, but that's how I read it. That was certainly a problem in the past where the prosecution had to request the order, but I don't read this legislation as going back to that model.
Just going to ask one more question, and then I'll give the floor to my colleague, Mr. Van Popta. When we talk about child sexual abuse material or child sexual abuse and exploitation material, referred to in the code as child pornography, but I don't want to use that term here. My understanding is that the research says that a number of people who consume this type of media, if memory serves, upwards of 80%, will eventually offend against a child. Not only over the internet, but in person. Now, would that not itself be justification for mandatory registration for these types of offenses? Professor Fair, go ahead.
Sure. So the constitutional question turns on this very narrow principle of justice called overbreadth. So if you can find one case where this would apply in a way where that person predictably would not be able to offend or would not likely offend, then the Supreme Court says that this is a violation of Section 7 of the Charter. I've written as to why I think, in fact, that principle of fundamental justice is not fundamental to justice at all. But then it goes to Section 1 justification. And the question we would have to consider is whether the discretion that's been so problematic, whether that getting rid of that and the offenders that will fall through the cracks is worth catching those one oddball cases where we might be able to find someone who is not unlikely to reoffend.
Mr. Van Popta here.
Okay, Professor Benedette, thank you for being here. Thank you to all of you. Now, Professor Benedette, you said that you affirm or you agree with what Professor Fair had said about listing the reasons that a judge cannot consider in determining whether or not somebody's name should be added to the sex offender registry. Could you expand on that? I think that's going to be important for us when we do our clause by clause.
Sure. So I'll just give you an example. So right now in the criminal code, when we talk about an application to access counseling records, third-party records, private records of the complainant, there's a list of factors that the judge is not supposed to consider, or at least are not sufficient justification for ordering production. And that was done specifically to try to counter some of the problematic and myth-based reasoning that we had seen in the past.
So Ms. Benedette, I'm going to interrupt you now, and we'll go to our next questioner, and perhaps you'll have an opportunity to pick that up. If I don't do that, we won't be able to. So, Mr. Housefather, you have 6 minutes, unless it's Mr. Maloney.
It's actually Mr.
Maloney, thank
I think
you.
it's me, yeah. Thank you, Madam Chair. I want to thank all the witnesses for being here today, and echo what Mr. Caputo said, except I've not taught in any of your classes before. Dr. Benedict, I'm going to start with you. You started by saying that you prefer the dissent, and then you went on to say that the trigger with respect to the mandatory bans is too high. I'm not agreeing or disagreeing with you, but do you have specific suggestions on how the language of the legislation could be changed?
Yes, I would recommend that the trigger for mandatory registration get rid of the reference to prosecution on indictment and simply say that where it is an offense committed against a victim of under 16 or 18, depending on the offense, and a sentence of imprisonment is imposed, that ought to be enough as the mandatory trigger. I think that would help. I understand that, we're trying to keep that mandatory no exceptions ban for a limited range of circumstances. But to me, that's more coherent than trying to make a distinction between indictable and summary or federal sentences and provincial time.
And that would include eliminating the 2-year threshold too.
I would, so long as it was a sentence of imprisonment, whether conditional or custodial.
To the other witnesses, do you agree with that? Mr. Fair, I'll start with you.
Yes, I also wonder, given the Ndlovu decision, whether it would be possible to just get rid of discretion at all in the context of child sex offenses. Now, it may catch some offenders that it ought not, but the Supreme Court has never said that a bright line rule is entirely unconstitutional. That goes to Section 1 justification of the rule. And again, given my concerns with the way that discretion has been exercised in the past, this might be something that could be upheld. The Supreme Court was dealing with a much broader application of a mandatory order in Ndlovu, and this would be a much narrower mandatory order.
Okay, Ms. Parker, what about you? Do you agree as well?
I actually agree with Professor Fair. Like, I think that would be constitutional if you limited it that way. And in fact, I could just refer back to, ironically, an old case, the 1988 case I referred to in a different context, Canadian newspapers, where there is a really specific reason for a removal of discretion, because that was the issue in Canadian newspapers, was the discretionary nature of the ban versus mandatory. And they found that when it's linked to a laudatory objective, it's constitutional. And so I think that limited approach that my friend is suggesting could withstand a constitutional challenge.
Okay, thank you. So, all right, Dr. Benedict, I'm going to go back to you again. You talked about the guiding factors in the legislation that judges are supposed to apply. I forget exactly how you characterize it, but I think the word vague was used. So what criteria would you add to make it less vague or make it meaningful, in your opinion?
Well, right now it says things like the judge can consider the nature of the offense, the circumstances of the victim, but all of those invite or at least permit stereotypical reasoning. So I would like to see an addition of a list of factors that the judge cannot consider or cannot rely on as a basis for exempting the offender from registration. That the offense was opportunistic or unplanned, that the offender was intoxicated, that the offender no longer practices the profession that gave them contact with the victims, that no additional violence was required to carry out the offense, because those were the things that we saw again and again drove the decision to order exemptions, and they're all based on myth and stereotype about what a real sexual offender looks like.
Okay, and do you have what you would consider an exhaustive list of criteria that should be excluded? I mean, you've given some examples, but if you have a detailed list, I'd like to see it, or you could send it to us.
Yeah, maybe I could forward that, and that would be more useful than trying to read out a long list here. And
Mr. Fear looks like he wants to chime in on this too.
I would note, Professor Benedict, I have your paper on my computer right now. It's page 473 of her 2012 Queen's Law Journal paper, where she has set out a list. So maybe that would be of help.
Okay, so we're going to get a copy of page 473. Okay. And anything else you might add, Dr. Benedict? Ms. Parker, what about you? How do you feel about that?
I would commend her entire paper to you, not just that singular page.
Okay, that's a couple of pretty strong endorsements, Doctor. Okay, so just very quickly, I don't have much time left. You talked about the Crown's ability to speak with individuals about the ban. How would you change the draft legislation or the bill that's before us to ensure that your concerns are addressed?
So I guess it depends how far you're going when you do your line-by-line amendments. We have all spoken about the need for robust or at least funded legal counsel for complainants, because right now people like Ms. Stevens and I are volunteers, and we're both sole practitioners, and so our ability to serve in that capacity is quite limited, just for really practical reasons. But if you want me to specifically go to a line-by-line analysis, perhaps I could also send you a note as well.
If
That
you do have
would
a
be
specific
terrific.
thought, then
Yes.
Please share.
Yeah, and for all witnesses, please feel free to send us anything that we don't have time to go over with today. That would be very appreciative, but the sooner the better.
We'd be happy
Yeah,
to do that.
that's terrific. Yes.
Thank you.
Now, Monsieur Fortin, la parole est à vous.
Mr. Fortin, you have 6 minutes. Please go ahead. Thank you, Madam Chair. Good afternoon to everyone. our three witnesses. Your participation is important in this debate, and I'm very proud and very pleased to be able to have the benefit of your knowledge. I agree with what the chair has just said. We would be very pleased to hear any suggestions. Page 473 of Professor Benedette's paper seems to be very useful. I look forward to reading that. I have a few questions about some aspects of the bill, but first, the publication bans are supposed to involve the prosecutor and the victim. What I wonder is how we can express something useful that would limit a little bit the prosecutor's conversation or communication with the victim in offering that advice. How could that be done effectively? It can become complex, of course, but are there any other things that you would suggest along that? Should it be the judge that explains this to the victim? Should it be the prosecutor? Should it be independent counsel? Should we always ensure that there is independent counsel when there is a publication ban possible? So, Ms. Parker first, please.
I'll answer you in English if you'll allow. Thank you. I'm just going to turn up to 3.2 in the legislation, and just in the very simplest of ways to eliminate the problem, but not to eliminate one problem, but not solve the other. You can simply delete the section that says the prosecutor has to advise of the ban's effect and the circumstances in which they may disclose information, which is the subject of the order. That would remove the giving of legal advice from the prosecutor, and I think that's, what we're saying is a serious problem. Solving that, though, is that we've said that somebody needs to explain it, and the judge isn't really in a position to explain the effects, because, of course, any good giving of legal advice involves receiving information. It involves a conversation that's privileged and confidential so that someone can understand the scope of what they're advising. And so really independent legal advice is what's needed here. And we even have cases where we've applied to lift publication bans, where we have tried to limit our involvement and ask the prosecutors to do this. And then the prosecutors come back to the complainant and they say, we can't agree to do it unless the complainant has independent legal advice. And so we say, well, all right, then appoint me. Then I want to say to the judge, then you need to appoint me as counsel. The prosecutor can bring an application to do that. We do that in other areas of the code. And so perhaps looking at that and importing that sort of concept from 276 and 278 into this area would be good, although you have to be careful about standing. That opens up a whole other mare's nest. So I can give you some answers. This duty to inform of the existence of the publication ban could also be equally imposed on the judge in the same way that a judge does a plea inquiry. That would also work. But we also have to bear in mind when the bans are imposed and that it needs to be easy to impose them early. So when is that duty triggered? At some point, somebody needs to tell the complainant, and there needs to be a legal duty to do so. The other thing I'll just note is that a complainant can't mistakenly breach the publication ban. There is a mens rea element to this offense. You have to know that a publication ban exists, and the prosecutor would have to prove that beyond a reasonable doubt to successfully prosecute someone for breaching a publication ban. It's a little detail that gets lost when we have this sort of discourse. I just want to raise that for the committee's consideration when you're thinking about this in the amendments. Thank you for the question.
I understand what you're saying, Ms. Parker. That is, that it would be useful for a victim to have independent counsel's advice. But from what I understand, and maybe I'm incorrect, but is that it's simply a matter of explaining what is going on. It could be the prosecutor, it could be the judge. saying to the victim, there is a publication ban, and so you can't talk about this matter. You can't say this or that thing, but not necessarily in an exchange between the victim and the judge. That doesn't necessarily happen. So should it be a situation where victims can consult independent advice if they want to, but not necessarily?
Favor of independent advice because the meaning of broadcast, transmit, or distribute has become more complex with the arising of social media. And so, for example, on the Department of Justice website, on the page about publication bans, they actually have something that's incorrect in advising complainants about that, saying that they can't talk about the publication ban with reporters. Well, of course
I'm
they
really
can.
sorry. I actually missed I think we're quite a bit over too, but I will. So our last questionnaire then would be Mr. Garrison, and 6 minutes.
Yes,
Thanks,
Madam Parker.
thanks very much, Madam Chair. Maybe I just let you finish that thought that you were on, if it hasn't disappeared already.
I think
It has.
I think it has.
Okay.
I'm a little nervous being at the committee.
Okay. Well, and I
I'm
want to
not
start
as
then.
used to it as you all are.
I want to start then by thanking you for being here and for the work that you do, largely on a volunteer basis, and also doing it as a survivor. I know it takes a toll, and I know being here today will take a toll. So thank you for that. I want to talk. I'm going to ask my questions all to you because we have the shortened time and not another round. When we talked to officials and we asked about the number of publication bans, I think there was a little bit of confusion. And I guess what I'm asking you is it normal and almost always the case that a publication ban is imposed?
So, yes, I was here that day as well, and I think the Department of Justice official answering quite correctly in his role as Crown wanted to give you very specific and precise answers. They don't keep those statistics, but if you had statistics for the number of sexual assault charges, then you would have the answer to that question because they are imposed in each and every case at the earliest opportunity. And in fact, if the Crown were not to ask that they be imposed, they'd probably be in breach in Ontario, at least of their own Crown policy manual, and in other jurisdictions like the Northwest Territories as well.
Thank you for that clarification. And in all of these cases, what would you say are the number of cases where a complainant is actually notified in current practice? Does this actually take place?
I think the complainant is generally notified in and around the time they come to court to testify. So if the case is resolved before there's any testimony given, the complainant isn't notified of the publication ban. I speak to that on the basis of my experience representing complainants, but also in my own case. I was never informed whether or not there was a publication ban in my own case.
And if a case is resolved before going to court, the publication ban would continue. Am I correct?
Correct.
And so we have people who may never been informed, the case is resolved, and they still don't know
Yes,
they're subject
exactly.
to the ban.
Yes, exactly. And I've represented some of those people, and we've often had a very difficult time trying to find out whether there's a publication ban at all. Sometimes we have to resort to ordering transcripts of every appearance at the cost of the complainant.
And I take your point about there being a mens rea, that it has to be kind of a deliberate violation. But can you say a little bit about where those who are subject to the ban have gotten into trouble? What are they trying to accomplish when they're talking to other people or informing other people about their case?
I think there's a bit of a misunderstanding, and I think CL's prosecution unfortunately increased that about what actually constitutes breaching the publication ban. But people are often given advice because of her case not to speak to anyone about it. For example, after our testimony 2 weeks ago, we were here with survivors. There was a woman here who is trying to get her publication ban lifted. We took a photo of all of us with her, and then we took a photo of all of us without her, so that the My Voice, My Choice people could use the photo in social media. She was worried that would breach the publication ban. So it's quite broad. People want to speak, write, speak in private groups, speak to counselors. These are the things that are worrying them. Whether or not those are violations would have to be, advice would have to be given on a case-by-case basis.
Could we amend S12 to put some of that, maybe advice into S12 by saying that in the case of talking to counselors or medical professionals or trusted persons, some kind of list of people where it's definitely not a breach?
Yes, you could. There is a section in here that speaks to the intent and how the complainant, about prosecuting the complainant and what would be required to do so, which I think just restates the law as it presently exists. But you could also carve out exceptions and circumstances under which someone should never be prosecuted. You could carve out an exception to never prosecute a complainant at all. Some would say that might go too far because there may be situations where there are multiple complainants where the public good would require that someone have a ban when they might personally not have wanted one.
I think that's an important point that you raised, that there are often multiple victims involved in a case, and there may be different opinions
Exactly.
about publication bans. But I guess in my own view, I think the suggestion, which came from my voice, my choice, that we might be more specific in the law about some of those circumstances where it's never going to be able to be prosecuted. One of the other things that I know, certainly from people I've met, constituents who've been subject to bans, has been the public safety aspect from their point of view. That one of the reasons they didn't like the publication ban, and one reason they wanted it lifted, because they wanted people to know that there was a predator.
Yes.
And that the publication ban on their name inadvertently protected the perpetrator.
Yes, exactly. And that's, of course, a benefit that the accused receives in the context of sexual assault cases that is unique in the criminal code. And so survivors who have the ban lifted in those circumstances are very brave.
Thank you. Thank you very much. Thank you very much to the panelists. Professor, you can go to your, to your class. So we very much appreciate you being here with us today on virtual there. And thank you very much for coming. That concludes the panel. We will now suspend for a minute because I believe the panelists that are with us for the next round are here with us in person. No one, okay, so please come on up. meeting back to order. Alors, nous sommes de retour. J'aimerais souhaiter
We're back now, and I would like to welcome our two witnesses. That is Dr. Benjamin Roebuck of the Federal Ombudsman for Victims of Crime, and also from the Women's Legal Education and Action Fund, Pam Rick, Executive Director.
Solicitor. So welcome to both of you. You both have 5 minutes each. What I'll do this time is when you have 30 seconds, I'll go like this. And then when there is absolutely no time, I'll go like this, and I'll do my best. So the floor is yours. I'll begin with Ms. Rick.
Thank you, Madam Chair. Good afternoon. As has been mentioned, my name is Pam Rick. I'm the Executive Director, General Counsel of the Women's Legal Education and Action Fund, or LEAF. We use litigation, law reform, and public legal education to advance the equality of women, girls, trans, and non-binary people, and we've been at this since 1985. I'd like to thank you for inviting me here to speak with you today about Bill S-12. I was pleased to also have the opportunity to appear before the Senate committee studying this bill earlier this year. I am going to focus my remarks today, as I did before the Senate committee, on the publication ban portion of Bill S-12. We were very encouraged to see the willingness of parliamentarians to improve how publication bans are imposed, varied, and revoked. This work has been driven to the forefront of public attention by sexual assault survivors themselves, including those involved with My Voice, My Choice, with support from feminist lawyers, advocates, and organizations like LEAF, who echo the calls for change to center survivor choice. LEAF was very glad to see the Senate amend the legislation in response to concerns that were raised at committee. We had several overarching recommendations for amendments to strengthen the bill in the Senate. These included, first, ensuring victims are not criminalized for failing to comply with the publication ban on their own identity. Second, ensuring that people whose identities are protected by a publication ban can still disclose their identity in contexts such as with a therapist or a support group. And third, clarifying and simplifying the process for revoking or varying a publication ban. These recommendations were put forward by a coalition of organizations and individuals with deep expertise on sexual violence in the legal system. They included LEAF, the National Association of Women in the Law, the Canadian Association of Elizabeth Fry Societies, Ending Violence Association of Canada, Legal Advocates Against Sexual Violence, Possibility Seeds, Megan Stevens, Pamela Cross, and Robin Parker. Of course, I'm here today speaking for LEAF. We would urge you, by and large, to maintain the amendments to the legislation that were adopted by the Senate, which were responsive to our recommendations. One modification we would encourage you to consider at this stage was spoken to by Ms. Stevens on October 5th and was just spoken to by Ms. Parker now, and that concerns the requirements the bill places on prosecutors. As you've heard, the current version of the bill requires prosecutors to inform complainants of the existence of a publication ban and their right to apply to revoke or vary it. These are practical and important information requirements that should be maintained. However, of course, the bill goes farther and requires prosecutors to share information about the publication ban's effects and when and how the complainant can disclose information without violating the order. That verges on putting the prosecutor in a position of giving legal advice. I agree with Ms. Stevens and Ms. Parker's submission that the bill should impose a more narrow requirement to inform a complainant of the ban's existence, that they can seek to have it varied or revoked, and that they are also entitled to get independent legal advice to make an informed decision about whether they wish to do so. As I said before the Senate Standing Committee, we need investments in independent legal advice and education to ensure that survivors fully understand what a publication ban does, how it can be imposed, and how it can be removed. We need these investments to ensure that survivors can make informed choices about what's best for them in their circumstances. We've heard loud and clear from survivors that they want the ability to speak about their own experiences, or at least some of them do. We also know that some survivors do wish to avail themselves of the privacy protections provided by a publication ban. As one expert, Anu Dugal of the Canadian Women's Foundation said earlier this year, publication bans can serve as, quote, one layer of support and protection for racialized women in a system that does nothing to actually support them or protect them, and in fact goes out of its way to harm them. I want to highlight that, unfortunately, it seems like the committee may be moving to clause by clause without having heard directly from any racialized survivors or legal experts concerning the impact of the proposed amendments. I'll conclude, though, by stressing that both choices are valid, to have a publication ban in place or not. The important thing for this committee to keep in mind is that amendments related to publication bans must seek to give effect to survivors' choices and make it as easy as possible to exercise agency in making those choices. Thank you, and I look forward to your questions.
Thank you very much. Mr. Roba?
Thank you. It's nice to see you again. Madame la Présidente.
Honorable Chairman and members of the committee, thank you for inviting me to speak on Bill S-12. I acknowledge that we are on the traditional, unceded, unsurrendered territory of the Anishinaabe Algonquin Nation. I honor the leadership, strength, and wisdom of Indigenous peoples, and I accept personal responsibility for pursuing justice and reconciliation.
Federal Ombudsperson for Victims of Crime is an independent federal agency, arm's length from Justice Canada. We provide information to the public on victims' rights, review complaints from victims about federal agencies, and advise on criminal justice legislation and policy. Our recommendations are informed by conversations with survivors and stakeholders across the country and around the world, and our Indigenous, academic, and service provider advisory circles. The volume of inquiries and complaints to our office continues to grow. We project a 128% increase in files opened this year versus 2017. Our office has also prepared a comprehensive response to this committee's study on improving support for victims of crime that we will submit to you shortly. To the courageous survivors who have advocated for S-12, thank you. I also recognize survivors who continue to be silenced by publication bans, and I've heard how painful it has been to be excluded from this process, not allowed to speak to Parliament with your own voice and name. One survivor provided consent for me to share their silence for 30 seconds. Please join them in silence. In June, I appeared before the Senate Standing Committee to discuss S-12. I'm pleased to see how the senators incorporated feedback from survivors and other stakeholders. I continue to support recommendations from My Voice, My Choice and other survivors who've contacted our office, including better education for prosecutors and judges on how trauma affects memory, processing information, and how important autonomy over identity is for recovery. Collecting reliable court data on publication bans, informing sexual assault survivors about their rights, respecting their choices, and offering independent legal assistance where available. Treating criminal code provisions for victims of crime with the same weight as measures for the accused. And better protecting the therapeutic records of sexual assault survivors who need unconditional safety to externalize and process the violence imposed on their bodies. Some of these recommendations are addressed in the bill, while others will require more work. We've heard about numerous rights violations, barriers, and contradictions in how the criminal justice system responds to sexual violence. Our office is in the early stages of planning a systemic investigation into these challenges to propose more comprehensive and trauma-informed remedies to Parliament. In a recent discussion with Crown prosecutors, we heard that the requirement to consult on publication bans in S-12 occurs prior to their regular first contact with complainants. This raises the concern that the implementation of S-12 could lead to rushed decisions on publication bans. We've also heard concerns that some survivors may choose to reject or lift a publication ban without understanding potentially long-term consequences. I understand the need to pass S-12 quickly, so I'll limit my recommendations to a few key areas that could easily be written into the legislation or included in implementation. One, informed consent. Decisions about publication bans have significant consequences for survivors. The pros and cons should be clearly presented with supporting resources that provide information in plain, easy-to-understand language. Trauma can make it difficult to process and recall information, so having something to review can help with decision-making. We propose the addition under duty to inform in subsections 486.4 3.2 and 486.5 subsection 8, requiring the prosecutor to inform the judge or justice that they have provided a resource on publication bans to explain the law, safety considerations, and how to have a ban varied or revoked. Finally, victim-centered information. I can summarize to shorten my time here. It's wonderful that we've included a measure for victims of crime to finally be asked if they'd like to receive information about the sentence and its administration. That's really important. It still remains offender-centered in the way it's presented. It's not clear that if a victim doesn't check that box, that they're not going to be told about a parole hearing, about when the person who harmed them has been released, and there's consequences to that as well. So we need to improve some of those measures.
Thank you very much. So, colleagues, we will do one round of 6 minutes each. I won't shorten that. We have enough time for that. And I will start with Mr. Van Popta.
Thank you. Thank you, Madam Chair. Thank you to the witnesses for being here. You've given very important evidence about one aspect of Bill S-12. Your focus has been on publication bans, which is very important legislation, and we are generally supportive of it. But I just want to get on the record how profoundly disappointed I am that the government, that the government side of the House has delayed this legislation and is now rushing it through. We have a deadline of October 28th in response to a Supreme Court of Canada decision that said that the sex offender registry was unconstitutional. So Bill S-12 intends to fix that. But now, on top of that, we also have this second add-on of a publication ban. And, you know, listening to your evidence today, Ms. Rick particularly, you say, you know, there's a lot of voices that haven't been heard. And here we are in a big rush of October 28th to get this whole bill passed. And I just don't feel that we're giving just time to this very important piece of legislation. Now, that said, that off my chest now, I do want to thank you for your testimony. But perhaps you could, we've heard from other witnesses that have said there should be a simplified process for eliminating, revoking the publication ban in simple cases. But perhaps you could tell us what, in your mind, constitutes a simple case.
I'd say perhaps a case where there is a very narrow scope of individuals who are covered by the publication ban, so a single individual, a single victim or complainant, where nobody else's interests are impacted. So that is juxtaposed, of course, with cases where there are multiple complainants, where there are different privacy interests that may be competing, where you have different desires among those individuals to have the privacy protections of a publication ban and those who do not want those privacy protections. So I think that's the kind of case that might be a little bit simpler. And I do think that the amendments that have been proposed and adopted by the Senate to simplify the process are a great improvement over what we have now and a great improvement over what Bill S-12 initially proposed.
Thank you. Now, there's often cases where there's more than one victim. And of course, there might be a disagreement amongst the victims as to whether the publication ban is important or harmful. So a case like that would be more complex. What would be the process then for revoking the publication ban for one victim but not the others?
So I'd hesitate to give a blanket answer, and I think the legislation provides for a process that allows those voices to be heard and for courts to consider whether a tailoring of a publication ban could address those various privacy interests. So I think it would be a case-by-case determination, and that S-12 does give the tools to the court to be able to make that kind of decision, one that hopefully, to the greatest extent possible, allows for every victim or complainant's wishes to be taken into consideration and to ultimately be respected.
Okay, thank you. Does the court have the resources to be able to do this in an effective manner?
I think the courts are under-resourced as a blanket statement.
Fair enough. I would agree with you, certainly from evidence that we've received in this study and others. I have a question about Crown prosecutors being given this additional task of having to deal with victims and publication bans. And I don't know which one of you said about I think you were indicating that there might be a conflict of interest between, for the Crown prosecutor to have to give what effectively becomes legal advice. So perhaps you could expand on that. Maybe you, Mr. Robeck, could talk about that and tell us what needs to be amended in the draft legislation.
Thank you. Yeah, I have a sympathy for that conflict of interest that I've been hearing about. I think independent legal advice is one of the most important components for survivors. It's a complaint that we have, that even though programs to provide independent legal advice exist, nobody has a responsibility to inform victims when they report a sexual assault that they can access those programs. And so it's a gap. We don't tell victims about their rights up front, and so they miss out on exercising them. For multiple survivors, I don't understand why somebody in cases with multiple publication bans, where somebody would need to retain theirs to respect someone else's. I think in cases with multiple bans, that somebody should be able to have their own removed and still respect any bans that remain in effect. And I think that that's a clear distinction. Otherwise, we have a system where people are still trapped with these silencing measures, and I think that that needs to change.
Fair enough. I'm good.
Thank you very much. Madame Anjou. Dylan.
And thank you to our witnesses for being here. I'll start with Madam Rick. We've talked with very good reason about, under Section 12, about victims who wish to lift their publication ban. And I'm going to ask in two parts, if you can answer, please. I want to ask you about the victims who do want a publication ban to protect their privacy, but are there parts of Bill Section 12 that, Bill 12 that could create barriers or confusion for people who do want a publication ban? How can we balance the interests of both?
What I think Bill S-12 does right now is centers that issue, as I said in my opening remarks, of ensuring that survivors can exercise choice and agency in determining what choice is best for them in the circumstances. So Bill S-12 allows for publication bans to be put in place right off the bat, which, acknowledged, and you've heard this at this committee, can feel like a suffocating or re-traumatizing experience for some survivors. So putting in those mechanisms to easily allow for the ban to be lifted, varied, revoked, that's an important measure to give effect to those survivors' choice. Having the discretion, the ability still present with the amendments in Bill S-12 to allow for that protection to exist and persist for survivors who do wish to avail themselves of the privacy protections of the ban, that is also something that I think this bill as drafted currently achieves as well. I do want to also reemphasize, just that the court resourcing point. It's not just the courts are under-resourced, it is that resources need to be directed in a way that is going to allow survivors to be supported in the process if they choose to report, and also to allow them to make choices about whether to report in the first place. So I could go on and take up most of the committee's time talking about ILA programs that exist for survivors, for example, in Ontario, to help them make those choices and the need to expand those across the country and properly fund them.
Thank you for your answer. And how do the provisions of S-12 better reflect victims' rights to information under the Canadian Victims' Bill of Rights?
That I would actually defer to my panelist on.
Thank you. I think that the victim's right to privacy is often interpreted for them and not in a way that benefits them. And so it helps to bring more choice to the way that privacy is exercised and allows people to choose whether they want those measures in place. Some people certainly want them, and some people definitely don't. And I think that we need to respect that people have different trajectories, different things that help them heal and feel protected. So choice is really important under the Canadian Victims' Bill of Rights.
Perfect. And my question is for both of you. Either one of you can answer. How can the information on the Justice website and the victim services materials be improved to better educate the public on publication bans? And what kind of information would you like to see in those resources?
I mean, I would like to see a plain language explanation of exactly what the law is once and if Bill S-12 is passed by the House of Commons. And of course, with any amendments back to the Senate, if a Parliament approves that, I'd like to see plain language resources for survivors to explain exactly what the legislation requires. I would like to see a one-stop shopping, ideally, of resources that survivors can avail themselves of to receive support, to receive guidance, hopefully to receive independent legal advice where it exists. Those are the kinds of things that I'd like to see housed in one place. And again, the plain language nature of it is so important, especially when people are accessing those resources in a time of intense trauma.
Yeah, I think that the risks of removing a publication ban need to be clearly explained. What does this mean in terms of media engagement, people taking your story, your experience, and broadcasting that without your consent if the ban has been removed? That's really important that that's understood. And then I think within the justice system, we have this opportunity, I think, to provide better information across the board. For someone who's accused, they have legal advice to walk them through the whole process and explain everything. We don't do that with victims and complainants, but we could at least have a set of resources that explains the process at a bare minimum that's provided proactively to people as they navigate the system, plus independent legal advice.
And to follow up with your comments just now, we often use the word trauma-informed or victim-centric to refer to, our aspirations for the justice system, what we'd like to see. In the context of publication bans, how can we make this a reality?
I think it's taking a step back and saying, who is this about? The system exists because someone was harmed, and often they're peripheral to the process. I think that really has to be the starting point, that we look at who was harmed, what does justice look like, what's required, and really have that be centered in the process. That will lead to different decisions and different investment of resources.
And I think just if I can piggyback off of that point, within 30 seconds, it also calls for looking at ways other than the criminal system to provide that kind of justice to survivors, to look at restorative justice or transformative justice options, to look at centering survivors' healing in the process and to giving them choice in how they go about that healing path.
Thank you very much. Monsieur Fortin?
You have 6 minutes. Thank you. Thank you, Madam Chair. And thank you to the witnesses for being here this afternoon. Your participation is valuable to us. I want to talk about an aspect that is important in S-12. It seems like it is a little bit of a side issue because we're really talking a lot about publication bans. I think those are a serious issue. We've heard from victims here who've testified on this bill and others. I'm always a bit, I may be wrong, and please correct me if I am, but it seems to me that there are various aspects that come up in all of these issues. When it comes to publication bans, clearly not everybody is going to read the criminal code or the part that is being amended by S-12 and understand clearly what they can and can't do. I think it should be possible to produce materials, and I think that Ms. Dillon talked about this. We heard Ms. Parker respond. We should have information to help victims decide whether or not they do want a publication ban, because victims need to understand the implications of having a ban or not. On a case-by-case basis, prosecutors could respond to questions or clarify certain things, perhaps every judge could provide some resources, and that's already done for certain aspects. But there must be a way to provide information that is really targeted. So generally speaking, do you feel that it would be possible to produce some kind of a tutorial, perhaps get people with teaching experience involved so that victims understand what their rights and obligations are when it comes to publication bans?
I think a lot of those resources already exist. Provinces, territories, federal government have resources that explain the justice process, but nobody has a requirement to provide them. And I think there's this simple bridging mechanism that we can say, you know, people who experience harm should at least be provided with this information. People don't know what to ask for. The CVBR requires them to ask for information, but you don't know what's available. And so I think we need to reverse that onus to say, when somebody reports a sexual assault, this is information that should be provided to them. When they experience a homicide in their family, this is important information. I think that's an easy thing that's low cost. The resources already exist. We just need a mechanism to provide it proactively.
Mr. Roebuck, I agree with you. And that's why it seems to me that S12 is doing that. The prosecutor will have to answer the judge's question, that is, whether this is what the victim wants. And if there are thorny questions, then that document could be provided. I think that something should be and can be provided in the wording because we need to protect victims. We have to therefore take into account what their wishes are. It seems to me that in our criminal system, this needs to be done and is missing. The obligation on prosecutors, in my opinion, doesn't put them in a conflict of interest because the prosecutor, in principle, should be there to establish the truth. So I would like to hear your views on that a little bit more. That is, this possible conflict of interest for a prosecutor answering questions from a victim about publication bans.
To this a bit, not just with my LEAF hat on, but also with the experience of having advised complainants in 276 and 278.1 applications before the court. You don't want complainants and survivors having in-depth conversations with the Crown that are unnecessary to the process, because that triggers, as you've heard from multiple people here, disclosure obligations. And I have seen in my own practice examples of young women in particular who are experiencing trauma, who are in an unfamiliar and hostile environment in many respects, not being in a position to understand that the Crown is not their lawyer, that victim witness assistance program practitioners here in Ontario are not their counselors, are not their specific advocates, that things that are told to them are then disclosed to the defendant. And that creates really awful knock-on effects that we want to avoid. So that is why we go back to independent legal advice being incredibly important, providing that solicitor-client privileged space for complainants and survivors to have those conversations and get the advice that they need. On the issue of education, I do want to quickly say there's such a need to invest in that in a way that brings experts into the conversation. Otherwise, you leave it to not-for-profit organizations, I could talk about this more, to provide these resources, and we're just not adequately resourced to do it.
Thank you, Ms. Rick. And our last questioner, Mr. Garrison, for 6 minutes.
Thank you, Madam Chair, and thank you to both the witnesses for being here. Mr. Roebuck, I know at the end you kind of ran out of time, and so I was very interested in the path you were starting down. Maybe you could say a little bit more, because we've been focusing, certainly I've been focusing my questions on publication ban, which is the front end, and you were talking a little bit about the back end, if you like, of the process. So could you just maybe give us a bit more on that you ran out of time talking about?
Yeah, thank you. Can you imagine if in your family someone was murdered and the federal government didn't think that it was appropriate to let you know that the offender was being released, or that you could participate in a parole hearing, but they didn't tell you that it was happening? That's the problem. Nobody has a legal responsibility prior to S12 to inform people, certainly on the federal side, about how to register to receive information. And that's a major source of complaints to our office. You know, women who participated in the National Inquiry into Missing and Murdered Indigenous women and girls, who have family members who disappeared or were killed, and still, after all of that process, aren't being told about these hearings and about the release of people back into their communities. So this has to happen. I think we need to improve overall information. I'll just highlight why independent legal advice is really important in sexual assault. We've had a complaint recently where somebody said, I wish that someone had told me to speak to a lawyer before I reported to the police, because I told them that I had seen a counselor and that I was journaling. And so both of those things became part of the disclosure, and they were subpoenaed by the offender. And in the end, they stayed their charges because it felt like such a personal invasion. And so this is happening across the board, where survivors' experiences are not being protected in the way that we do justice. And certainly this issue of therapeutic records, which I know has passed through the Supreme Court and had different perspectives, but I don't think that a survivor-centered perspective has been fully considered on that. And it could be better protected with independent legal advice.
And so the suggestion has been made that certainly we could amend S12 at least on the prosecution possibility to add a list of circumstances which would not result in prosecution, that would include things like counselors, legal advice, trusted individuals for minors. So you would say that would be an addition that would be important?
Yeah, I don't think that a survivor should be criminalized through a measure that the federal government thinks is respecting their right to privacy. It just doesn't make sense. I think sometimes we arrive at these spaces that don't make sense when we step back and consider them. We can do better than that for people who experience violence. We can be respectful and honoring and helpful. And, you know, even the possibility of criminalizing someone for, you know, talking about their body and their experiences, that's violating. It's not respectful.
Thank you. Maybe, Ms. Rick, you can talk about what happens in practice, though, even though all of us might look at the bill and say that this shouldn't happen in case of prosecution. We are actually hearing that it does happen because of that misunderstanding of the law.
Yeah, absolutely. And I think you've heard the best kind of evidence on that point from people like Robin Parker and Megan Stevens. And I urge you to listen to that based on their decades of experience representing survivors, and also their experience as both Crown and criminal defense lawyers as well. I think one of the good things about Bill S12 as it's currently drafted is that it makes it much clearer. So a line Crown prosecutor can go to the legislation and see, oh, it's not appropriate for me to pursue charges because the three criteria there are not met. And then it doesn't have to be something that is a matter of discretion, that they sort of are figuring it out in some cases really quite poorly, as evidenced by the examples that we've heard about, but setting it out much more clearly and being very narrow about the circumstances in which it would ever be appropriate to pursue that, I think is another good thing about this legislation, that clarifying element of it.
And I want to go back to you, Mr. Roebuck. In terms of victim services being provided and legal aid, you made a remark about legal aid, people not knowing legal aid's available. My impression is that it's not always available, and maybe that's because I'm from a different province. So maybe you can say something about that, and then I'll go to Ms. Rick on whether legal aid is actually available.
I think the federal government, through the Victims Fund, has done a pilot project across the country to fund independent legal assistance in cases of sexual assault, and are piloting as well in cases of domestic violence. And so for now, we have a system that we can use, but we certainly need to consider how to better embed those rights and services for survivors into the justice system.
So at this point, it's only a pilot, though. It's not
permanent funding,
permanent funding,
from my understanding.
Yeah.
Legal aid is also drastically underfunded, and something I would like to see governments at the provincial and the federal level increase investments. And I think we saw in Ontario recently an announcement of the first tariff increase, I believe I'm getting this right, the first tariff increase in maybe over 10 years, and it's just 15%. So legal aid certificates, where they are even available, certainly do not pay those who are taking them very well, and that narrows the scope of people who will take them. And it also results in the narrowing of fields for which they are available, or charges or matters, for example, family matters, for which they are available. So underfunding of legal aid is another major justice issue.
Great. Thank you. I'm about to get the red flag. Thanks very much.
Thank you very much to our panelists. Thank you, colleagues. Just a reminder, if you think there's anything you wanted to say and we're not able to that you have handy, please send them to us as soon as you can. And reminder to colleagues, if you have amendments, please see the legislative for amendments. Otherwise, thank you very much. Have a nice evening, and we'll see everybody here Thursday. Adjourned.